Alright, this is another legal letter from someone else other than the first legal letter I just read. It's the same exact legal letter. Faith continuance. Alright, this is a little different just based on the fact that this individual is not claiming to be going out of... Wait, what? To promote judicial efficient. Hang on, the same flights purchased and paid for prior to... Alright, this is slightly different, so I'll just read it. The Circuit Court of Florida, case number has a bunch of X's in it. Family, Division Family, FS. Petitioner JDE and me. Petitioner's second motion for continuance. If you listen to the first recording, I never received a copy of the first motion for continuance, and I never received a copy of anything, even about a lawsuit or a trial date that I was even under surveillance of any kind. I don't mean like surveillance, but like I didn't know there was a lawsuit against me. I didn't know there was court dates. I didn't know any of this because I evaded the cops. They could never serve me. They still can't serve me, so that's causing these people some problems, I guess. So anyway, petitioner's second motion for continuance. Petitioner JDE, appearing pro se, respectfully moves this honorable court for a continuance of the hearing currently scheduled for March 5th, 2026. I had no idea that I had a court date in a few days. I had no clue. And states as follows. The petitioner previously filed a motion for continuance on February 9th, 2026. The grounds set forth therein remain valid and unresolved. Again, this is very similar to the first letter, but I'm reading it because it does have some case number changes. And I think that the first one, the petitioner said that she was out of the... What did she say? She was going... Okay, so this individual, we'll call them BSE. I read their lawsuit or whatever this is. I don't know what you call this thing. Their petition to get me in trial or something. Anyway, it says here in her number 3. Additionally, the petitioner has pre-existing travel plans requiring her to be outside this jurisdiction on the date currently set for hearing, and then offers these dates. And then this second petitioner, the second person filing against me, is requesting those same dates, but is not going to be traveling. I don't know. I know that these two are trying to put their lawsuits together as one, so if one's out of town, the other is probably allowed to have this continuance. Okay, here we go. The petitioner previously filed a motion for continuance on February 9th, 2026. The grounds set forth therein remain valid and unresolved. Number 2, to date, the respondent has not been served, that's me, despite multiple attempts by law enforcement. The petitioner has been informed that the respondent is actively evading service. Who informed them of that? Proceeding without perfected service would prejudice the petitioner. Little one. Law enforcement personnel have advised the petitioner that multiple diligent attempts have been made to serve the respondent since issuance of the February 2nd, 2026 order. Diligent, I wouldn't say so. Threatening, harassing, attacking, abusing me and my neighbors, that's not diligent. That is well, that is illegal, is what that is. You're torturing people for no good reason. All you had to do was show up with a social worker, not guns, but a social worker. That's all you had to do, people. But service has not yet been completed. Law enforcement further advised that the respondent is evading service. In an email dated February 7, 2026, oh, here we go. This is my favorite part. The respondent, that's me, referenced the officer's attempts and stated in all capital letters. I love how they put that in there. They say in all capital letters, like they actually say it. You don't, I don't know why you don't say it. It's just in capital letters, dude. Like, how stupid. And this is what they have never talked to me or seen me. They will never talk to me or see me. And that they are calling evading service. Those words from a disabled person. They're calling it evading service. Bipolar 1, on disability in the state of Florida, legally disabled, and they are calling it evading service when I call it torturing a disabled person. Number 2, accordingly, should personal service remain unsuccessful, the petitioner respectfully requests that this court authorize substituted, constructive, or alternative service as permitted under Florida law. Those don't sound fun at all. And grant such further relief as is just and proper. In further support of alternative service, the petitioner provides the following email addresses that the respondent has repeatedly used. They have no proof of that. I don't know why they're saying it like that. The respondent has repeatedly used to communicate with her. Again, no proof of that. These accounts are demonstrably active as the respondent continues to transmit communications to the petitioner through them as of this date. Given the respondent's ongoing use of these email addresses and the unsuccessful attempts at personal service, the petitioner respectfully requests that the court authorize service or notice through these electronic means or through such other method as the court deems reasonably calculated to provide actual notice to the respondent. Yeah, these people are talking about emailing me to let me know there's a trial. Or doing whatever the fuck they want to do is what that sounds like. Number 3, the petitioner has filed a separate injunction for protection against cyberstalking, stalking involving the same respondent as case number, bunch of X's in this one. The other petitioner in that matter has a scheduling conflict with the March 5th, 2026 hearing date. So these people filed a lawsuit against me, and now they're telling the courts that they can't make the case, they can't make it to court when the court is telling them to go to court. But when I'm not there to go to court, I'm evading law enforcement when I've never even been notified by anyone that there's even a lawsuit going on, and I'm supposed to be in court in like 8 days. So they don't care about my time. They don't care about my life. Doesn't matter what I have going on. I don't even have a lawyer. I don't even have anything, dude. To promote judicial efficiency and allow both matters to be addressed together, it is in the interest of justice to continue the hearing. In the interest of justice. Bear in mind, these people tried to murder me, and they stole all my retirement money. But that's all in the interest of justice, right? The flights, lodging. Are we still calling it lodging, people? It's 2026. Come on. It's not lodging. That's so fucking... and related travel arrangements were purchased and paid for prior to the court's issuance of the order setting the March 5, 2026 hearing. Number 4, the requested continuance is made in good faith and not for purposes of delay, but to ensure proper service upon the respondent and to allow petitioner a fair opportunity to appear and be heard. People, I don't even know what the laws are in Florida. I'm just a stupid artist. But I'm smart about one thing. When someone's at your front door with a gun, you don't answer it. Number 5, as an additional act of good faith and in an effort to assist the court, they're assisting the court here in promptly rescheduling this matter. That they're assisting the court by rescheduling. Petitioner provides the following dates, and then they tell the court when it's good for them. Isn't that wonderful? They file the suit, they get a court date, and they say, no, these are the dates that we will do it. A lot of ego there. Wherefore, again, capitalized. Wherefore is capitalized. Come on, just take it out of the letter completely. The petitioner respectfully requests that this court, you're not being respectful. You're trying to push the court around. You're trying to make everything the way you want it to be. That's not how it works. I actually have no idea how it works, but I'm finding out very quickly. Respectfully request that this court enter an order continuing the hearing presently scheduled for March 5th, 2026, preserving the temporary injunction for protection against cyberstalking issued on February 2nd, 2026, and granting such other and further relief